Hi, this is Kina Kim with PivotalDiscovery.com. We're at the Thomson Reuters 12th Annual Electronic Discovery and Records Retention Conference in Los Angeles. Today we're here with James Daley. He's the founder of Daley, Crowley, and chair of the Sedona International Working Group on e-discovery and data privacy. James is going to share with us his thoughts on navigating the rapids of cross-border e-discovery. James, thank you for being here.
Thank you, Kina. One of the traps for the unwary in e-discovery involves international e-discovery. There are three main areas that practitioners and corporate representatives need to be aware of. The first is that there are a lot of laws that restrict the collection and the transfer of particularly electronic information from outside the U.S. to bring it into the U.S. for litigation. Even though the U.S. courts do not give anyone a free pass and require discovery to be the same worldwide, there are nations, particularly Europe and increasingly in Asia, that are enacting regulations such as the EU Privacy Directive Act that severely limit that access to information. So no longer can a US company just go to an email server, for example, in Germany, and collect information that might be relevant to a litigation in the US. No longer can a governmental agency in the US go over to France or Switzerland and do broad-based discovery. Instead, those countries have enacted not just those regulations, but also statutes called blocking statutes. And these statutes are really very broad. They relate to the discovery of any information, let alone documents, in that country that might be used for another country's judicial or administrative proceedings. In fact, earlier in 2008, a French attorney was even criminally prosecuted and found guilty of violating that blocking statute in that country, was fined 10,000 euros, or the equivalent of $15,000, and is facing disbarment as a French attorney because of that act. And all that attorney did was act in conjunction with a U.S. law firm to try to talk with a potential witness who lived in France. So this is how dramatic the sanctions can be. They can include but not be limited to fines, and ultimately even debarment or restriction of the company's ability to do business in that country. Certain countries have their own flavors of data protection acts. This is another thing that's important to know from a legal perspective, that the European Commission, for example, has a minimum standard, but countries like Italy, France, Spain have exceeded that, and countries are able to exceed that minimum standard with even greater restrictions. The second thing to be aware of for practitioners and for corporate counsel is the cultural issue. And this really relates to records retention culture, because in Europe and outside the US, there isn't a culture of saving things for the purpose of legal reasons. This whole idea of legal hold notices and saving things that otherwise would not have business value doesn't exist. And employees don't understand why my email does not belong to me. Really, outside of the US, email and other personal information that identifies an individual is considered to be the employee's property. And unless there is specific consent given, that cannot be taken out of the country, and then only in certain circumstances. And the third area relates to information technology, because we know in this area of cost cutting in this time where we're trying to save money, a lot of decisions are being made about moving technology and document and information storage from one country to the other. We had a client recently that wanted to move their data centers from Frankfurt to Dallas, but we were able to catch them in time and talk with them about the data protection and privacy issues in moving personal information from particularly a European Union country to the US. And it wasn't just a matter then of information technology, it was a matter of compliance with various laws. So in those three areas, knowing the law that may well differ outside the US, where outside the US, data privacy is considered a fundamental human right, whereas in the US it's only observed in certain areas like healthcare and social security numbers and financial information. Secondly, knowing that there's a big cultural difference in not having addressed these issues before. So a lot of room for education, training, sensitivity, and being aware that you have to be a translator to those that aren't familiar with not only records management, but the U.S. discovery culture itself. And third, IT, that there are decisions and actions made in the IT sector that very well may be impacted by these international data protection rules and blocking statutes.
Great. Thank you so much, James.
Thank you.